Okay.
Okay, no further policy matters. That sounds good. Okay, next would be public comment, and I'll say any person may bring their concerns about matters not on the agenda before the board. Speakers are requested to limit their remarks to 2 minutes unless otherwise allowed additional time by the board. Is there anyone who has signed up to speak and address the board at this time?
We do not have a list, but if anybody from the public would like to address the board, if you just hit the hand icon, we'll call on you and unmute you. And Madam Chair, I do not see anybody wishing to address the board.
Okay, thank you. Okay, the next item on the agenda are complaint matters, investigative matters. But before that, I'd like to ask the staff to be sure and turn the recorder on. And I would like to make a motion to enter into executive session. So I'll start with, this is Dina Falbo. Today is February 2nd, 2023, and the time is 9:03. This is a meeting of the Colorado Board of Mortgage Loan Originators, and I move that this body enter into executive session pursuant to Colorado Revised Statutes, sections 24-6-402, parens 3, parens A, parens Roman numeral 2, and section 24-6-402, parens 3, parens A, parens Roman numeral 3 for the following purposes: to confer with counsel to receive legal advice on specific legal questions regarding the matters noticed on the agenda as complaint matter A, number 2022-1878, complaint matter B, 2022-1879, complaint matter C, number 2022-1882, complaint matter D, number 2022-1883, complaint matter E, number 2022-1881, complaint matter F, number 2022-1884, complaint matter G, number 2022-1885, complaint matter H, number 2022-1887, we're halfway there, complaint matter I, number 2022-1886, complaint matter J, 2022-1888, complaint matter L, 2022-1890, complaint matter N, 2022-1889, complaint matter O, 2022-1891, complaint matter P, 2022-1893, complaint matter Q, 2022-1892, and finally, complaint matter R, 2022-1880. To receive legal advice regarding applicable legal basis to discipline an MLO license pursuant to sections 1210-711 and 1210-713 Colorado Revised Statutes, and to discuss legal memorandum addressing board discretion to discipline an MLO license under these provisions, and also including licensing matter A, 2022-1927. To receive legal advice regarding applicable legal basis for denial of an MLO license under sections 1210-711 and 1210-713 Colorado Revised Statutes, and to discuss legal memorandum addressing board discretion to deny applications for licensure under these provisions. May I have a second?
I second.
All in favor of entering into executive session, say aye.
Aye. Aye.
And I am an aye as well. The board is exiting the public meeting to convene in a closed executive session conducted remotely, and staff ensures that this session will be recorded. Okay, I see you over there. Okay. Okay, let's see, I'll try to see if I can see everybody. If you could let me know when everybody is back, then I'll go ahead and.
Can you hear me?
Yes.
Okay.
Can you hear me?
Yes.
Back.
There she is. Okay, it appears that we're all back. So I'll say this is Dina Falbo. The board is now, the time is 9:42 and board is open. Board is now back in open session. Okay, so back to the agenda items. We'll begin with the complaint investigation matters. And yes, I'll turn it over to investigator reports.
So board members, the first complaint A, is case number 2022-1878. This investigation was completed by Carolyn Dionese Wright. In a multi-state investigation, it was determined that a former education provider completed in-person and online education on behalf of hundreds of MLOs across the nation. They granted course credit to the MLOs who had enrolled in the approved courses, but who neither attended the course nor completed the coursework necessary to receive the course credit. As a result of the settlement, the respondent agreed to the following: to surrender all current MLO licenses and withdraw all MLO applications of participating state mortgage regulators, wait at least 90 days from December 27th of 2021 before applying for or seeking reinstatement of an MLO license, payment of $12,000 in administrative fines to be divided equally between the participating state mortgage regulators, and complete 28 hours of MLO education courses prior to applying for or seeking reinstatement of an MLO license. Potential violations are 12-10-713-1M, any Part 9 or rule violation, 12-10-713-1W, action in another jurisdiction, and Board Rule 5.23D, disclosure of discipline in another jurisdiction. We do not have a recommendation, and Carolyn is here to answer any questions that you may have.
Thank you so much. Okay, board members, do we have some discussion?
We sure do. So I guess I can lead off by saying to our board here that we're tasked with, because there's so many cases now, we're tasked with some consistencies moving forward, and how we're going to approach it. Some of them are a little different if they reported the situation or not, but they all violated. And it's now what we're tasked, how we're going to look at this and move forward, which we want to open that discussion. A couple of ideas that we want to talk about is the public censure, adding fines, and we'll just open that up. So what are your thoughts?
Yeah, I mean, I definitely think, given kind of what we're looking at, we need some consistency. Yeah, it's really challenging.
It's a tough one. I know in the past that we have had zero tolerance for basically, for lack of a better word, lying. And it is our job to, protect the public. And so for people to be so blatant and lie about how they're getting their license was really bothersome to us as a board. Go ahead.
Right, but now in efforts to be consistent, just as you guys are describing, I think it's important that we keep in mind the possibility of actions in other states hinging on our decisions. So with that said, it's important for the protection of, Colorado consumers that there be something in place that states that there was an issue here with each particular person in the complaint that we're faced with. So, something to the effect of a stipulation of final agency order with public censure, meaning that obviously that would be known to the public, and final agency order. And there would be a legal basis for that, which we could choose one of those of the suggestions that the board made easily and do that. It's just a matter of deciding if we want to just stick with that or add any fines to that as well.
Right. And I think it's important to mention and for the public to know that in each of these cases, these people have paid fines.
Right.
Multiple fines in some cases.
Correct.
So they did.
And in all cases that we've seen, that they've all met the demands of, the settlement order. So it would just be, finally how Colorado wants to handle this in regards to protecting the public of Colorado. So with that being said, I would be willing to make a motion to set up a stipulation of final agency order with public censure based on 12-10-713-1W. Is there any discussion? Does anybody want to add any fines to that, or are you okay with that?
I would like to see a fine added.
Okay, do you have a suggestion?
The other states fined $1,000, and I think that that's appropriate.
Okay, so I could amend my motion to a stipulation of final agency order and public censure based on 12-10-7, along with a $1,000 fine based on 12-10-713-1W. Do I have a second? Do I have more discussion?
I would second.
Okay.
Okay, all in favor, say aye.
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 And I am also an aye. Okay, moving on.
So board members, complaint matter B is case number 2022-1879. This is another investigation completed by Carolyn Dionese Wright. In a multi-state investigation, it was determined that a former education provider completed in-person and online education on behalf of hundreds of MLOs across the nation. They granted course credit to the MLOs that had enrolled in the approved courses, but who neither attended the course nor completed the coursework necessary to receive the course credit. As a result of the settlement agreement, the respondent agreed to the following: surrender of all current MLO licenses and withdraw all MLO license applications of participating state mortgage regulators. Wait at least 90 days from January 6th of 2022 before applying for seeking reinstatement of a mortgage loan originator license. Pay $30,000 in administrative fees to be divided equally between the participating state mortgage regulators, and complete 28 hours of MLO education courses prior to applying for seeking reinstatement of an MLO license. Possible violations are 12-10-613-1M, any Part 9 or rule violation, 12-10-713-1W, action in another jurisdiction, and Board Rule 5.23D, disclosure of discipline in another jurisdiction. And we do not have a recommendation for you, but Carolyn is here to answer any questions you may have.
Okay, thank you. So any further discussion on this one? Do we want to keep it consistent in regards to the conversations that we've had before, and can make a motion, simply make a motion to, and I can do that, making a motion for a stipulation of final agency order and public censure along with a $1,000 fine based on 12-10-713-1W.
The only comment I would make is my notes said that it appeared on this one that he used that cheating scheme to get licensed in 38 states. Just for the record.
Right.
That's a lot.
Yeah.
So I feel that the public censure is warranted on this one as well as the fine.
Yeah, and I would second your motion, Dina.
I
Okay,
agree. Mhm.
all in favor, say aye.
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 And I'm also an aye.
And I apologize if I missed it, Chair Falbo. Was that also based on 12-10-7-13-1W?
Yes, yes. Okay, next matter C.
So complaint matter C is case number 2022-1882. This is an investigation completed by David Levy. In a multi-state investigation, it was determined that a former NMLS education provider completed in-person and online education on behalf of hundreds of MLOs across the nation. They granted course credit to the MLOs who had enrolled in the approved courses, but who neither attended the course nor completed the coursework necessary to receive course credit. Potential violation is 12-10-713-1W, action in another jurisdiction, and we don't have a recommendation for this case either. David is here to answer any questions that you may have.
Thank you.
I
Okay.
think we stay consistent again, Dina, and go with the previous motion.
Okay, I can go ahead and make that motion. I'll make a motion for a stipulation of final agency order with public censure and along with a $1,000 fine based on the legal basis of 12-10-713-1W. All in favor, say aye.
Aye.
You
I'll
need-
second it.
Oh, yeah, sorry. I forgot that
That's
part.
okay.
May I have a second? Okay.
Yeah.
All in favor, say aye.
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 And I am also an aye. Thank
And I
you.
will note for the record on this one, at least he did disclose.
Right. Right.
Yes.
Okay, matter D.
So matter D is case number 2022-1883. This is an investigation completed by Pat Hardy. In a multi-state investigation, it was determined that a former NMLS education provider completed in-person and online education on behalf of hundreds of MLOs across the nation. They granted course credit to the MLOs who had enrolled in the approved courses, but who neither attended the course nor completed the coursework necessary to receive course credit. As a result of the settlement agreement, the respondent agreed to the following: surrender of all current MLO licenses and withdrawal of all MLS or MLO license applications of participating state mortgage regulators. Wait at least 90 days from January 2nd of 2022 before applying for seeking reinstatement of an MLO license. Pay $8,000 in administrative fines to be divided equally between the participating state mortgage regulators, and complete 27 hours of MLO education courses prior to applying for seeking reinstatement of an MLO license. Possible violations are 12-10-713-1W, action in another jurisdiction, 12-10-713-1M, any Part 9 or rule violation, and Board Rule 5.23D, disclosure of discipline in another jurisdiction. And we don't have a recommendation for this one. Pat is here to answer any questions that you may have.
Okay, thank you. So I have a note on this one that the license was surrendered in January of 22. Is that still the case? Is that still the case? Is the license surrendered or is the license active? It does say active, but I wasn't sure.
He is currently active in Colorado. Yep.
Okay. Okay, so I guess we would again keep our consistency with this one along with the others, unless there are further discussion. I can make a motion.
Well, I did want to note that I think he said that he realized what was going on with this scheme and signed up for another program. So I think that's slightly different in that that's commendable that he tried to self-correct in this situation.
Do you want to make that, you know, a reflection of that in regards to the motion, maybe not including public censure or something of that sort?
I would say maybe a reduced fine. Half.
Okay,
Half, that would be my recommendation.
okay. Well, I can go ahead and make that motion, a stipulation of final agency order with public censure and a fine of $500 based on 12-10-713-1W. May I have a second?
I second.
All in favor, say aye.
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 And I'm also an aye. Thank you.
To board members, complaint matter E is case number 2022-1881. This is an investigation completed by Charles Riquet. In a multi-state investigation, it was determined that a former NMLS education provider completed in-person and online education on behalf of hundreds of MLOs across the nation. They granted course credit to the MLOs who had enrolled in the approved courses, but who neither attended the course nor completed the coursework necessary to receive the course credit. As a result of the settlement agreement, the respondent agreed to the following: surrender of all MLO licenses and withdrawal of all MLO license applications of participating state mortgage regulators. Wait at least 90 days from December 30th of 2021 before applying for or seeking reinstatement of an MLO license. Pay $6,000 in administrative fines to be divided equally among the participating state mortgage regulators, and complete 28 hours of MLO education courses prior to applying for or seeking reinstatement of an MLO license. The possible violation is 12-10-713-1W, action in another jurisdiction. We do not have a disciplinary recommendation, and Charles Riquet is here to answer any questions you may have.
Thank you.
So I had a note on this one that the license was inactive. Is that correct?
And also, I'll sort of piggyback on Jen's question. And my note was there was something written in one of the exhibits, not planning on renewing for 2023. So yeah, is it an active license? And can we get any more details on
And
that?
he didn't write an explanation either.
Right, right. Yeah, just for the record, I'm going to go on record and make a point that to anyone who's possibly listening right now, it's really important that your letter of explanation tell us something important that we need to know, and include your thoughts and feelings about it or what you've done since then. Those are really important.
To board members, it looks like his license is currently expired. It expired on December 31st.
So having said that, is it still the same procedure in regarding a disciplinary action for a license that's currently not active? Is it the same as if it were active?
You can go ahead still and vote to impose discipline for the conduct.
Okay, thank you. Okay, then I'll go ahead and make a motion for stipulation of final agency order with public censure and a $1,000 fine based on a legal basis of 12-10-713-1W. May I have a second?
I'll second.
All in favor say aye.
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 And I am also an aye.
Okay, so board members, complaint matter F is case number 2022-1884. This is an investigation completed by Robin Coates. The respondent signed a settlement agreement and consent order related to the education scam investigation in which he was required to surrender his MLO license in California, Florida, Oregon, and to withdraw any application for a license in those states and not reapply for 3 months, pay a fine of $4,000, and complete additional education. The respondent has met all terms of the settlement agreement. Oh, sorry, I just lost the document that I was reading from. I'm back. Okay, so
there we go.
Potential violation is 12-10-713-1W, action in another jurisdiction. We don't have a recommendation, and Robin is here to answer any questions that you may have.
Thank you. Is there any further discussion on this? Does anybody have any further discussion on this one? I do have a note on this one.
Yeah, I had a note too, and I don't know if it changes what we would do, but the LO said that he called Dora and was advised that he didn't need to do anything. And I didn't know if we record phone calls, if we had any proof of that attempt and what Dora would have told him.
So we
So
don't,
I'm sorry,
Oh,
Marcia.
no, go ahead,
Excuse me.
Robin.
I don't know if I'm on video. I can't seem to get it to work on my end. But back to the question, I was unable to verify that. I can't say whether he did or whether he did not.
Okay.
Based on my conversations with him, and I tend to believe that he did make an attempt to report this incident to Colorado, and it didn't, and he has uploaded the information on the NMLS. So I wasn't able to dispute what he said, if that helps at all.
Yeah, I wanted to make, sorry, go ahead, Devin.
I will say from a legal perspective, they did not include on the referral a violation for failure to report. So that may be relevant to you.
Okay.
So maybe on this one, we do the reduced fine.
I was also considering that because I do read in the letter, this made it and a small impact on me, and that he said that he voluntarily did not engage in any lending activities for the first 6 months of 2022 in any states, even though he was licensed. So I feel like maybe this is a case of someone who tried to go above and beyond in regards to making sure that he wasn't violating anything else, or that they could come back and say that, anything in regards to practicing, mortgage lending at the time. So I do think that warrants a possible consideration of the fine, either the reduced fine or no fine, but just for discussion.
Based off of that, I would be comfortable removing the fine completely.
I would too.
I would also.
Okay, so I will go ahead and make a motion for a stipulation of final agency order with public censure based on 12-10-713-1W. May I have a second?
I second.
All in favor say aye.
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 And I am an aye as well.
The board members, complaint matter G is case number 2022-1885. This is an investigation completed by Robin Coates. The respondent signed a settlement agreement and consent order in which he was required to surrender his California, Hawaii, Idaho, Maryland, New Hampshire, Nevada, Oregon, and Washington MLO licenses and not reapply for 90 days, pay a $10,000 penalty in addition to that. The respondent was ordered to complete 20 hours of continuing education. The respondent has completed the terms of the settlement agreement. The respondent states in his response that he did not contact Colorado, as he was told by the NMLS investigators that Colorado was not involved, and that was the respondent's reason for not contacting our division. The respondent uploaded the settlement agreement into the NMLS and thought Colorado was aware of the settlement agreement because it was uploaded in NMLS. Potential violations are 12-10-713-1W, action in another jurisdiction, 12-10-713-1M, any Part 9 or rule violation, Board Rule 5.23D, disclosure of discipline in another jurisdiction. We don't have a disciplinary recommendation, and Robin is here to answer any questions that you may have.
Thank you. Is there any further discussion on this one particularly?
No.
No.
I think I have a question for Devin, possibly. I mean, obviously on this subject, but sort of off the subject. Where is it written? How am I going to rephrase this? So many of them say they thought that because NMLS reported it, that they didn't have to report to Colorado. How do you know? Where do they know that they're supposed to report to the state of Colorado as well, or to individual states as well as Colorado? Where do they know that? How do they know?
in the licensing law. So if you take a look at the text of Rule 5.23D, it actually gives the specific steps that an MLO would need to take after they're disciplined in another jurisdiction. And Rule 5.23D says they need to make written notification to the board through the online services portal found on the division's website within 30 calendar days.
Okay, so they know, they are aware, they're made aware. Okay, thank you for
If they
clarifying.
read it.
Yeah, for the active MLOs in the room. Yeah, yes, of course. Okay, so if there's no further discussion, I'll go ahead and make the motion for a stipulation of final agency order with public censure and $1,000 fine based on 12-10-713-1W. May I have a second?
I'll second.
All in favor, say aye.
Aye.
And I'm also an aye. Thank you.
Okay. Good morning, board. Your next item is investigative matter H. This is complaint number 2022-1887. In December 2021, the respondent entered into a multi-state settlement agreement and consent order requiring him to surrender his MLO license in all participating states for a period of 3 months before he could reapply for a new license in any of the respective states. He was also required to pay $7,000 in fines split equally among the states and complete 20 hours of PE and 8 hours of CE. The consent order stems from an NMLS investigation that learned of suspicious activity regarding an MLO education cheating scheme. The investigation found that the course provider gave fraudulent course credit to MLOs who did not attend the respective in-person and online courses. The consent order states that the respondent accepted 28 PE and/or CE completed by the course provider on the applicant's behalf under the in-person education scheme. The respondent was first licensed in Colorado as an MLO in September 8, 2021, and renewed on November 3rd, 2021, approximately 1 month prior to entering into the consent order. The respondent stated and appears that the CEPE referenced in the consent order was not related to Colorado. However, the division does not have record of the respondent notifying the division of the consent order. The respondent has begun the process of reapplying in the affected states and has obtained his new license in 6 of the 7 jurisdictions so far, including 1 new state. However, the state of Georgia revoked the respondent's company license and denied his individual license in January 2022 due to the consent order. Possible violations include 12-10-7131M violation at any Part 9 or rule violation, 12-10-7131W license discipline in any jurisdiction, and Rule 5.23D immediate notification. And the division does not have any recommended disciplinary action. I can answer any questions you may have.
Thank you, Eddie.
Eddie, did you say that Georgia denied his application?
Correct. I believe they revoked his company license and then denied his individual license.
Interesting. Okay. Thanks.
Yes, you're welcome.
Evan, would this rule fall into our guidelines where when they have been denied in another state, we're not to approve them?
There isn't a legal prohibition on so this is a discipline case to start with, so it wouldn't be a license approval that we're just talking about, but there's a license denial in another state would not mandate that you impose any certain discipline.
Thank you.
I feel for consistency purposes, I don't see anything that would be different in this one compared to the other ones so far.
I agree.
I agree too.
Okay, so I'll make a motion of a stipulation of final agency order with public censure and a $1,000 fine based on 12-10-713-1W. May I have a second?
I'll second.
All in favor, say aye.
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 And I'm also an aye. Thank you.
Okay. Your next matter is investigative matter I. This is complaint number 2022-1886. In December 2021, the respondent entered into a multi-state settlement agreement and consent order requiring her to surrender her MLO license in all participating states for a period of 3 months before she could reapply for a new license in any of the respective states. She was also required to pay $6,000 in fines split equally among the states and complete 20 hours of PE and 8 hours CE. The consent order stems from an NMLS investigation that learned a suspicious activity regarding an MLO education scheme. The investigation found the course provider gave fraudulent course credit to MLOs who did not attend their respective in-person and online courses. The consent order states that the respondent accepted 7 PE and or CE completed by the course provider on the applicant's behalf under the in-person education scheme and 3 PE and or CE under the online education scheme. The respondent let her Colorado mortgage loan originator license expire on January 1st, 2022, and waited until April 26, 2022 to reapply. Due to an internal oversight, our application was not flagged and was approved on May 3rd, 2022. It appears that the respondent acted as if Colorado was a party to the settlement agreement by letting her license expire and waiting over 3 months to reapply, which did include disclosure of the settlement agreement in her NMLS application. The respondent has since obtained her license in all the participating states. Possible violations include 12-10-7131W, license discipline in a jurisdiction. There is no recommended disciplinary action, and I can answer any questions you may have.
Thank you so much.
Yeah.
So I think this one warrants a little bit of discussion in regards to what she wrote in her letter of explanation.
Yeah.
Again, I will say for the record, I appreciate when people, get real in the letter and give us, more information. And for that reason, I appreciate what she said in regards to making the worst mistake of her life and the lapse of judgment and so on and so forth. So I don't know, does that warrant a lesser fine also for this one?
Yeah, I agree. I made a note too. Excellent letter of explanation. Plus the fact that it kind of slipped through the system.
Yeah.
And she did on her own discipline. I'd recommend no fine on this one.
My thoughts exactly. I agree with you, Cindy. Any further discussion on this one? Okay, go ahead.
Oh, I said no, sorry.
Oh, okay, that's okay. I'll go ahead and make a motion for a stipulation of final agency order with public censure based on 12-10-713-1W with no fine. May I have a second? Thank you. All in favor, say aye.
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 Aye. Okay, moving on.
Right. Next is investigative matter J. This is complaint number 2022-1888. In December 2021, the respondent entered into a multi-state settlement agreement and consent order requiring him to surrender his MLO license in all participating states for a period of 3 months before he could reapply for a new license in any of the respective states. He was also required to pay $14,000 in fines split equally among the states and complete 20 hours of PE and 8 hours CE. The consent order stems from an NMLS investigation that learned a suspicious activity regarding an MLO education cheating scheme. The investigation found that the course provider gave fraudulent course credit to MLOs who did not attend the respective in-person and online courses. The consent order states that the respondent accepted 34 PE and or CE completed by the course provider on the applicant's behalf under the in-person education scheme and 14 PE and or CE under the online education scheme. Although the respondent did disclose this information on his NMLS application profile, he did not notify the division of the settlement agreement. His MLO license was last renewed on November 1st, 2021 and was active until October 18th, 2022 when he voluntarily inactivated the license just prior to receiving the complaint notice. The respondent has begun reapplying to the participating states as well as new states and is currently licensed in only 5 states jurisdictions compared to the 14 listed in the settlement agreement. Possible violations include 12-10-7131M, any Part 9 or rule violation, 12-10-7131W, license discipline in any jurisdiction, and Rule 5.23D, immediate notification. There's no recommended disciplinary action, and I can answer any questions you have.
Thank you so much.
You're welcome.
Any further discussion on this one in particular? Questions, comments?
His Colorado license is effectively right now inactive, correct?
It was at the time I finished the report, and I was just going to double check that for you as we were speaking.
It doesn't really matter though, does it? Because the previous one that was inactive, we went ahead and stayed consistent with what we were doing.
It's expired as of January 3rd, 2023. So it inactivated on the date that I previously mentioned, and it's now expired.
Okay. Thank you for clarification.
You're welcome.
I will make a motion for a stipulation of final agency order and public censure, including a $1,000 fine based on 12-10-713 1W. May I have a second?
I second.
All in favor say aye.
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 And I am also an aye.
Thank you.
Good morning.
Good morning.
Okay. Investigative matter K is complaint number 2022-1325. On May 4th of 2022, the respondent was found to have violated the state regulatory registry's rules of conduct by paying an employee to complete his continuing education for the years of 2019 through 2021. It was recommended that the 2021 online continuing education courses should be retracted from the respondent's NMLS account, and that the testing and education investigation flag would be updated on his NMLS account, notifying all relevant mortgage regulators of the violations. The NMLS records were updated on September 22nd, 2022. The states that this conduct occurred in have yet to take action against the respondent. Possible violations include 12-10-713 1B, good faith, fair dealing, 12-10-711 1G, not having demonstrated good moral character. And we do not have a recommendation, and Investigator Martinez can answer any questions.
Thank you so much. I'm pretty sure we're going to have some discussion about this one, as it is a little bit different from the others. I'm sure there are some comments, questions. I'll open it up to the board.
Yeah, so I guess I'll start. I mean, one of the so obviously the loan officer has an attorney, so there wasn't a true letter of explanation really outlining what happened. But I did notice that, you know, the attorney said that the LO is reducing the number of states that he's licensed in, which will reduce the long-term burden of completing a significant number of CE hours, which that statement for me really solidifies the loan officer's true opinion on CE, that it really is a burden, and kind of makes me feel like that statement in and of itself provides kind of what the loan officer really feels.
Well, did I read it correctly too, that he wants to surrender his Colorado license so he can keep his Texas license?
So he stated that he is not working in Colorado, and currently his Colorado license is expired. But with regards to the surrender, I believe in the statement he had made mention that he would be open to surrendering the license.
But you said sorry, Paul, you said that his Colorado license has expired.
Yes, and he had explained that he has not been working in Colorado. So yeah, it doesn't sound like he has much interest in renewing the license.
So does he want to surrender it so that doesn't come? I'm trying to understand this, because he said he wanted to surrender it, but if can you surrender your license after it's expired?
So I
Devin,
think
that might be a question for you.
Yeah.
Yes, so the challenge I think is that after the license has expired, there's still a period of time where the the MLO could reactivate their license.
They can reinstate the license until the last day of February.
Oh, okay,
Okay.
in this case.
Okay.
I felt like they were asking for leniency in order to protect the other licenses by saying that, you know, he wants to surrender Colorado, but I do fear that once, you know, we get through this, if that is true, if we base our decision off of that, then we may reapply in March, you know, and maybe it wouldn't prevent his license really from being for reapplying pretty quickly after that.
Right, that's exactly my thought. I was thinking the same thing.
So board members, if you wanted to, though, if you wanted to allow him to surrender it, you could do a stipulation that allows the surrender, and then maybe, and we can work with Devin on this, include some language about there's a period of time before he can try to come back here.
Okay.
Yeah, I don't know. I kind of feel like what Jennifer said, I agree with. I mean, first of all, that's just blatant, having an employee take the CE courses for you. I mean, that's just outright blatant. And so I would.
And just from a legal perspective, I just wanted to mention that the MLO did not admit to doing that, and no other state has completed disciplinary action yet regarding those allegations.
So right. So this was reported, but no one has proven it yet, is what you're saying.
Right. He neither admitted to or denied the allegations, and no other state, at least as of the last update I had, no other state had taken any disciplinary action against him related to the allegations.
Thank you.
I'd have a tendency to agree with the violations that they recommended, and then add, you know, a year before he could reapply, and then go with our, you know, the public censure.
Yes, I agree with you on that in regards to something.
And so
further.
as you're thinking through the discipline, what was explained earlier is that the division, if you authorize the division to enter into a stipulation with the respondent where that stipulation involved voluntary license surrender for a certain period of time, that could be included in a stipulation. The question that I would have is, are you imposing any discipline and then authorizing the board to enter into, to pursue basically a stipulation involving those terms?
Yes, I believe that that's exactly the direction we would want to go. So what would be the language here in regards to that?
And so the question I would have then is what discipline you want to originally impose, because what Marcia was describing is a situation where you enter into a stipulation, an agreement with the respondent, where the respondent agrees to voluntarily surrender his license, which is what he had indicated that he would be willing to do, and that you do it for a certain period of time. But that's not discipline that you impose. That's you authorizing the division to enter into a stipulation for those terms, which would be a voluntary surrender, not treated as a revocation. I believe that's what you're intending. And then the question would be, if that's what you're intending, what discipline you would want to impose, if any, that would then lead to that possibility of that stipulation.
So I think, oh, I'm so sorry, Devin, go ahead.
No, that's fine. And so for example, if you wanted to do a final agency order, you could do a final agency order, and then with the other disciplinary tools that are available to you, whether you wanted public censure, whether you wanted a fine, and then in addition to whatever discipline you impose, also authorize the division to accept a surrender, not treat it as a revocation. I think that's what you're going for.
Yes, okay. I like that. That seems like it covers all the bases there, and the violations would be the suggested violations, one or both. Is that correct?
You could use either of those as legal bases, either or both as legal bases for the discipline you voted to impose.
And we could also include a fine of $1,000 per violation if we chose to go both?
That is correct. You have the authority to go up to $1,000 per violation.
Okay, I'm gonna shoot for the sky and make a motion here. Just please correct me if I'm wrong, but I'm gonna make a motion unless there's any further discussion from the board. I'll go ahead and try a motion. Okay, I'd like to make a motion for a final agency order, stipulation for a final agency order, including public censure, with a fine of $1,000, and also to accept the surrender. I'm not sure how to license verbiage this, but for the board to present a acceptance of the surrender of the license for a 1-year time period.
And let me ask you just a couple questions. So just I want
Okay.
to make sure we're clear on the fine. Did you want a single fine of $1,000 total?
Well, I guess if we do one, I was just gonna state the violations as 1210, 713, 1V, good faith and fair dealing for $1,000.
Okay. And then so just to restate the portion that you had just said, and if it's clear and that's the part of your motion, feel free to incorporate what I said as your motion. So you wanted to also authorize the Division of Real Estate to accept a voluntary license surrender from the respondent, where that surrender is not treated as a revocation, as part of a stipulation and final agency order that the division may negotiate with the respondent, including a provision that the respondent will not apply for another license within 1 year. Is that your motion?
I would like to add your verbiage to my motion. And before I get a second, I want to just put it out to the board members. Did you want to add the second violation of good moral character, not demonstrated good moral character at 1210, 711, 1G? Does anyone feel strongly to add that as well, or not before you make a motion? Or before you say that again, Cindy, I'm sorry.
I think you're good with the one.
Okay, so do I have a second?
A second.
All in favor, say aye.
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 And I am an aye as well. Thank you.
Okay. The next is matter L, complaint number 2022-1890. On January 9th of 2021, the respondent surrendered his mortgage loan originator license as a result of his involvement in a continuing education testing and education scheme in 2018. The respondent was ordered to surrender his license in 10 states and pay $11,000 in fines. The respondent provided proof of payment of the fines and did not reinstate his license in any of the states. The respondent explained that he has not practiced since his license relinquishment and does not plan on renewing his Colorado license in 2022. Possible violations are 1210, 713, 1M, any Part 9 or rule violation, 1210, 713, 1W, and Rule 5.23D, immediate notification. We do not have a recommendation, and Investigator Martinez can answer any questions.
Thank you so much.
Sure.
So he just got out of the business.
Right.
Sounds like it.
Mhm.
Let's see. I wanted to look at something first really quickly on one of the exhibits.
Well, I think also it was to me, it was unclear if he did the continuing education or not. He paid the fines, but I couldn't see if he did. To me, it was unclear if he did the CE credits or not.
He ended up getting them.
He did not.
This is one where, well, I'll say I felt the letter was very thorough, and I appreciate everything that he said in the letter in regards to, you know, trying to be honest and honorable, and that this was a painful ignorance on his part, and I appreciate him saying that. So for the end, because of the fact that the license is no longer, he doesn't plan on renewing his Colorado license, and hasn't been originating mortgages since all of this happened, I would be inclined to drop the fine to $500 on this one and for a lesser fine. If there's any further discussion on that.
I think that would be fine.
I agree.
Okay, then I will make a motion for a stipulation of final agency order with public censure and a fine of $500 based on 12-10-713-1W. May I have a second?
I'll second.
All in favor, say aye.
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 I,
And I am an aye as well.
Just to clarify, did you want all three of the violations or just one W?
No, just one W, please.
Okay.
Thank you.
Uh-huh. Okay, the next one is investigative matter M, complaint number 2022-91. On January 20th, 2022, a complaint was filed against the respondent. Complainant alleges that she contacted the respondent for a refinance and he provided a rate lock agreement and then could not be reached for 60 days. The complainant was later quoted additional fees that she did not agree to and decided not to proceed with the refinance. The complainant alleges that she missed out on lower interest rates with other lenders due to the time she wasted attempting to work with the respondent. Despite repeated attempts to reach the respondent by phone, email, and certified mail, the respondent has failed to respond to the division's correspondence. Possible violations include 12-10-713-1M, any Part 9 or rule violation, and Rule 5.9, duty to respond. Disciplinary recommendations include public censure, a final agency order, a fine of $1,000, and suspension of 30 days, and license inactivated with NMLS pursuant to 12-10-706 CRS. And Investigator Martinez can answer any questions.
Thank you so much.
Sure.
So, I mean, in terms of consumer harm, I mean, bait and switch is really a huge example of how a consumer can be harmed, and especially in this environment, you know, that we went through with interest rates. I mean, to have a consumer be, you know, to be a victim of a bait and switch and then also lose out on the interest rate is pretty significant to me.
Agreed.
yeah, this one kind of boggles us because I can't believe he's never responded.
Mhm.
The board, I mean, he's
Right.
just ghosting everybody. I also noticed that it looks like the license is currently expired. Is that the case too?
Yeah, that would have happened on December 31st.
So they haven't renewed. He's not anyplace else.
Right, and the recommendation included a suspension, but if the license is inactive, is what would be suspended?
Right. What would be?
Maybe this is another one where we recommend that they withdraw. Or is that the proper language?
So it's currently expired, so it's not as though they would be withdrawing an application, but you can still impose the discipline that you think is appropriate to make sure that even if somebody is expired, you can impose discipline because it's important the discipline appear on their record so that so that the public is aware of that discipline later. And for example, if you wanted to impose, if a suspension were what you wanted to impose, you could impose a suspension that would become effective as of any date that he was able to reactivate his license.
Okay, that's good to know.
Mhm.
And I had a couple other violations, you know, lack of good faith and fair dealing.
For sure.
And then, you know, the not fit.
Right.
So
Would you like to make a motion on that?
I guess I'll make a motion for final agency order with public censure, adding rules 1210, 713, 1M, any part of 9 or rule violation. Rule 5.9, duty to respond. Rule 1210, 713, 1Q, not fit. And Rule 1210, 713, 1V, lack of good faith and fair dealing, for a total fine of $4,000. And to add that we suspend the license for 12 months before he can reapply, if he even tries to reapply.
I think it would be a $3,000 fine then.
There's 4 violations.
One of the 4 violations is the 1210 713 1M, which is necessary for the rule 5.9. So as a practical matter, that would be three fines that would be.
Oh, 3. Okay.
Okay, we'll
So
amend that
3.
to 3.
With the 3,000 fine.
Do we have a second?
I'll second.
All in favor, say aye.
Aye.
And
Aye.
I'm also an aye. Thank you.
Okay, matter N is complaint number 2022-1889. On December 30th of 2021, the respondent entered into a settlement agreement and consent order regarding their participation in the Reese Mortgage Loan Originator testing and education scheme in 12 states. The respondent was ordered to a 3-month license suspension, a $12,000 fine, and completion of 20 hours of PE and 8 hours of CE. The fines have been paid in all 12 of the states. The respondent provided evidence that all of the required coursework was completed, and the respondent is actively licensed in 15 states. Possible violations include 1210, 713, 1M, any Part 9 or rule violation, Rule 5.23D, immediate notification, and 1210, 713, 1W, license suspended in any jurisdiction. We do not have a recommendation, and Investigator Peters can answer any questions.
Thank you.
So I had a question. I had a note that this person participated in Reese in 2017, but in 2018 through 21 took courses elsewhere. Am I remembering that correctly?
Yes, I believe she provided that in her letter of explanation. She did not provide evidence that she did that, but she did put that in her letter of explanation.
Okay, thank you.
I just don't understand when they continue to say, I didn't realize I was supposed to notify the state of Colorado. So we can be, I'll go ahead and make a motion to be consistent on this one as well. I'll make a motion of stipulation of final agency order with public censure and a $1,000 fine based on 1210, 713, 1W. Do we have any further discussion and or a second?
I'll second.
All in favor, say aye.
Aye.
And I'm also an aye.
And again, just to clarify, we are only using the violation of 1W.
Yes, that's
Okay.
right. Thank you.
Okay, the next is investigative matter O, complaint number 2022-1891. As a result of involvement with a mortgage loan originator testing and education scheme, the respondent executed a settlement agreement and consent order with the states of Florida and California on December 28th of 2021 and December 30th, 2021, respectively. Wherein MLO licenses were surrendered for a period of 90 days, and he was to pay a fine of $2,000. The fine has been paid, and the respondent is now relicensed in both states. The respondent also had to complete 20 hours of PE and 8 hours of CE. Possible violations include 1210, 713, 1W, license suspended in any jurisdiction, Rule 5.23D, immediate notification, and 1210, 713, 1M, any Part 9 or rule violations. We do not have a recommendation, but Investigator Gabarty can answer any questions.
Thank you so much. Well, I thought it was interesting. I'll just make a comment in a letter that he stated he knew the actions were wrong. So I was struck by the honesty there. And I don't know if that changes anything, but at least he came clean on that. Does anybody have any further discussion on this one?
I say you move forward as the others.
Okay. I'll make a motion of a stipulation of a final agency order, including public censure and a fine of $1,000 based on 12-10-713-1W.
I second.
All in favor, say aye.
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 Aye. Thank you.
Investigative matter P is complaint number 2022-1893. On December 28th of 2021, the respondent entered into a settlement and consent order with the states of Arizona, California, and Florida as a result of involvement with a mortgage loan originator testing and education scheme. The respondent was ordered to 90 days of license suspension, a $3,000 fine, and to complete 20 hours of PE and 8 hours of CE. The fine has been paid and the respondent currently has active MLO licenses in 7 states. Possible violations include 12-10-713-1M, any Part 9 of rule violation, Rule 5.23D, immediate notification, 12-10-713-1W, license suspended in any jurisdiction. We do not have a recommendation, and I can answer any questions you might have.
Thank you so much.
Sure.
Any further discussion on this one as well? Basically the same.
Yeah.
Okay.
Stay consistent.
Yes. I will make a motion of a stipulation of a final agency order with public censure, including a $1,000 fine based on 12-10-713-1W.
Second.
All in favor, say aye.
Aye.
Thank you. I'm also an aye.
Okay, investigative matter Q is complaint 2022-1892. As a result of involvement with a mortgage loan originator testing an education scheme, respondent executed a settlement agreement and consent order with the states of California and Idaho on December 8th of 2021. The MLO licenses were suspended for a period of 90 days. He was required to pay a fine of $2,000 and complete 20 hours of PE and 8 hours of CE. The fine has been paid. Evidence of completion of the PE and CE was requested but never received. Possible violations include 12-10-713-1M, any Part 9 or rule violation, Rule 5.23D, immediate notification, 12-10-713-1W, license suspended in any jurisdiction. And we do not have a recommendation, and I can answer any questions that you might have.
Thank you.
As before.
Okay. All right. There we go. I will make a motion for a stipulation of final agency order and with including public censure and a $1,000 fine based on 12-10-713-1W. May I have a second?
I'll second.
All in favor, say aye.
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 Aye as well. Thank you.
Madam Chair, you're doing a fantastic job.
Thank you. I got my notes. I've got it all written down. Thank you so much. You're so sweet.
So board members, complaint matter R is case number 2022-1880. This is an investigation completed by Charles Riquet. In a multi-state investigation, it was determined that a former NMLS education provider completed in-person and online education on behalf of hundreds of MLOs across the nation. The provider granted course credit to the MLOs who had enrolled in the approved courses, but who neither attended the course nor completed the coursework necessary to receive course credit. As a result of the settlement agreement, the respondent agreed to the following: surrender of all current MLO licenses and withdrawal of all MLO license applications of participating state mortgage regulators, wait at least 90 days from January 18th, 2022 before applying for or seeking reinstatement of an MLO license, pay an $11,000 administrative fine to be divided equally between the participating state mortgage regulators, and complete 28 hours of MLO education courses prior to applying for or seeking reinstatement of an MLO license. The potential violation is 12-10-7131W, action in another jurisdiction, and Charles Riquet is here to answer any questions you may have.
Thank you so much.
I just wanted to note that I felt like in the LOE, I could feel the attitude coming out of it. And I definitely felt that he was really inconvenienced, which I did not appreciate.
I will 100% agree with you. The letters are so important to me as well, and the attitude that came across in the letter was evident. I don't know if that changes anything, but
as I just felt the need to note that.
Yeah, I'll agree 100%. Did we have any further discussion in regards to anything else, or shall I go ahead and go forward with a motion? Okay. I will make a motion for a stipulation of final agency order and public censure, including a $1,000 fine based on 12-10-713-1W. May I have a second?
I second.
All in favor say aye.
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 And I am an aye as well. Thank you.
Investigative matter S is complaint number 2022-1580. On August 29th of 2022, the respondent pled guilty to 2 counts of sexual exploitation, child, induced, enticed, a class 3 felony. The respondent was sentenced to 20 years in the Department of Corrections with 237 days credit, 36 months mandatory parole, $489 in court costs and fees, and to register as a sex offender. The remaining balance is $449.87, and the respondent is currently incarcerated. Possible violations include 12-10-713-1N, conviction, 12-10-713-1P, fail to notify conviction or plea. Disciplinary recommendations are final agency order, revocation, and a fine of $2,000. And Investigator Martinez can answer any questions.
Thank you so much.
Sure.
Okay, so on an entirely different subject, is there any specific discussion in regards to this?
This is horrific.
Right.
And revocation will go with the recommendation. Absolutely.
It was very hard to read.
Yeah.
It was upsetting to read, and I think we have limited choices here. I mean,
and board members, the one thing I would mention is actually you are required to revoke this licensee. 12-10-711-2 requires you to revoke the license of any licensee who has pled guilty to a felony within the immediately preceding 7 years. As surprising as it may be, 12-10-713-1N and 12-10-713-1P do not include this crime in the category of crimes that fall within it and that must be reported, which leaves us with a single violation that would be up to a $1,000 fine rather than a $2,000 fine.
and that would be the 12-10-711-2.
That's correct. The violation of 12-10-711-2.
Okay. Would anyone like to make a motion on this?
I'll make the motion to revoke the license based off of 10-12-711-2.
Oh, wait, can you just rephrase that real quick? Because you said 10-12 instead of 12-10.
Oh, 12-10-711-2. I'm sorry.
There we go. No problem.
And did you want that as a final agency order?
Yes.
With public censure?
Yeah, with public censure. And let me know if anyone disagrees. I don't feel the need to include a fine based off of the fact that he will be in prison for an extended period of time. I don't really think it's necessary, but let me know if anyone disagrees.
I agree.
I actually agree with that because it's not likely going to get paid anyway. Right. So do we have a second?
I'll
I
second.
second.
All in favor, say aye.
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 And I'm also an aye. Thank you. Okay, so I believe that concludes our, let me see, did we get to the bottom of that list? Yes, that concludes our complaint matters. I want to ask the board if you want to consider taking a short break before we move on to licensing matters, or are you okay to continue on? That's up to you.
Short break would be great.
Okay, Devin, what am I supposed to say when it's time to take a break? Let's see here.
If you could indicate what the time is right now that the board
Okay.
will temporarily be in recess, and let people know when the board will be resuming
Back.
business.
Okay. Okay. So the time is currently 10:51 a.m. The board will be taking a short break and will resume back here at 11:05 a.m. And do I need to take a motion? Do I need to take a vote on that?
I don't think you do.
Okay. Okay. We'll be taking a short break. We'll resume at 11:05, giving everybody a few minutes.
Thank you.
Thank you. Okay. Okay, well, I have 11:02, so we can wait a couple minutes so we make sure that all the staff is here at 11:05.
So you guys were so right when you told me the last meeting in January was a very short one.
This is not normal.
Oh,
Yeah.
okay.
Somewhere in the middle.
All right. Gotcha.
Not quite this big, not quite that small.
Gotcha. Okay.
And you're doing great, Shirley.
Yes, you really are.
Oh, thank you. Thank you. I'm just glad I don't have to do any of those motion things because thank you both.
Yeah. And thanks, Dina, for jumping in there.
I just figured,
on the
yeah,
canned response.
for the consistency, I would make it simple, but
That's awesome.
You all are doing a great job. Thank you so much, board members. You're all amazing. And we had a big agenda today and we had a lot to cover. So thank you for all your hard work and dedication to the board.
Well, I just think the staff is amazing because looking through all the stuff that gets presented to us, the amount of work that goes into behind the scenes on that.
Yeah, I know the investigators are incredible. Like we have a couple new ones.
Yeah, they're all incredible and
Couple
so
new
thorough.
investigators.
Well,
I mean,
first, board members, thank you. I think, so we don't really have any new investigators on staff, but I think you're seeing some that have only worked for the Real Estate Commission, but due to the volume of these, we got to spread the wealth.
Yes, right. Yeah, for sure. Okay, well, I see that the time is 11:05 and we are now back in open session. So we can continue on with licensing matters.
So board members, licensing matter A is case number 2022-1927. This is an application. The applicant signed a settlement agreement and consent order as part of the NMLS education provider education scam. This investigation was completed by David Levy. He is here to answer any questions that you have, and we don't have a recommendation.
Okay, thank you so much. Appreciate that.
This
Okay,
seems to be a similar situation as we were dealing with before, so I think we stay consistent.
okay, well, due to the fact that this is a license application and not a complaint matter on an active or inactive license,
Okay.
maybe we have some other thoughts or comments in regards to this. And
I felt like because the applicant holds a leadership position, you know, I expect more integrity and due diligence for them, for leaders in a company. And so I was disappointed in that. And then I also noted that one of the LEs and the letters of recommendation are in the exact same format and font, which I know we've seen before, but is a curious observation.
yes, very good observation, by the way.
Good point.
Okay.
Are we feeling as a group, though, that moving forward, that for a new license that we would approve, and then we would also have a final agency order as we've done previously? So can we do that? Can we discipline and approve?
I don't think I've ever heard of that happening before, because really all that we're looking at here is the license application, unless Marcia has seen something different.
No, the only thing that we've had the boards do is like maybe issue a restricted license. The thing about your program, though, is there's not the kind of the layer of supervision like we have with other programs where the restricted license comes into play.
Right.
But it's a decision of whether you issue or not.
Right, yes or no? And we
Yeah.
can have public censure.
No, you usually don't. When considering an application, you don't like grant them one and then automatically discipline them something for their background.
Okay. Okay.
Well, I will make a comment in regards to the letter, the personal statement, actually. I felt it was a good personal statement. I appreciated some of the comments about changing the way things are done going forward. I should certainly hope so. You know, trying to do what's right with clients and colleagues. I do agree with your comment, though, Jen, in regards to being a person in that position to be even more, you know, thorough in regards to, you know, what's happening. So, I mean, I'm kind of on the fence about this one. I feel somewhat positive about it, but at the same time, I agree with that point entirely. So,
yeah, because I also feel conflicted because, you know, giving all of what we just looked at and we did discipline to then approve a license, really as is, knowing the background feels a little conflicting.
Should we consider asking them to try again after a certain amount of months, ask them to withdraw and reapply. It's not.
And my feelings on that are that not necessarily, I don't know if that really meets, does anything specific in regards to the license application, because the settlement order has been completed. I don't know. Do we feel will that serve some kind of purpose, or is that serve some kind of purpose, or just sort of put off your application to another day?
Yeah,
I don't know.
I don't feel like it really does anything. And if we're looking at potential consumer harm, I mean, whether we approve it today or we approve it in a year, I mean,
right,
the difference in that.
Right.
That's a good point.
What'd you say, Cindy?
I said that was a good point. Sorry.
Yeah.
But I do think, as we also talk into the future for future applicants with this issue, again, I think we need to have a consistent position. And so if we decide to approve this application, then I think that would then set a standard going forward for other applicants with this situation.
And I believe we have approved some in the past. I don't know if somebody could correct me if I'm wrong, but I think we have.
I think we approved one, and because that person felt it was suspicious, so they actually took additional CE in a year.
Right.
That was the only one that we have approved.
Good memory.
And I know we have one new board member, and just for consistency purposes, I believe that is correct. Of those who had been previously considered that were involved with the scheme, all the license applications were denied except for the one that was just mentioned, is my recollection.
Okay.
Yeah, I personally don't see just approving it and sending them through, because that just does not seem like a good thing in the light of, in the view of protecting the consumer. That's just not okay. But it sounds like we sort of have the option of approving or not. Those are our options.
That's right. Deny or approve.
And we can deny with the opportunity for them to withdraw, so then it doesn't show up.
Right. Or harm them in other states.
Right.
What'd you say, Cindy?
Like she was saying, they can withdraw instead of, we can say we're going to deny, and they give them the option to withdraw their application, and then it won't show up in the NMLS as a denial. It'll show as a withdrawal, and that, won't hurt them in other states.
Is that what was done in the past?
Yeah, we were pretty hardcore on,
So,
although I think we gave them an option to withdraw.
So just to be clear, board members, with the previous applications that you did not provide an opportunity for the applicants to withdraw their applications, the ones who were involved with the same scheme.
Right.
Okay. And would a question for you, Devin, 1210, geez, I lost it already. 1210, 713, 1W still apply on this one? This would be a basis.
If 1210, 713, 1W, right, would be one potential basis that you could use to deny the application. The other would be 1210, 711, 1G. And 1210, 713, 1W is the disciplinary action taken in another jurisdiction, with 1210, 711, 1G being financial responsibility, character, general fitness to command the confidence.
General fitness, gotcha.
Well, this is a tough one, because if existing licensees can pay a fine and have public censure, but continue working, and yet a new applicant doesn't have that opportunity, That's tough. And yet we can't, wow, okay.
Yep, you nailed it. You know,
I think
they're part of that lawsuit. They did pay their fines. It has been a couple years. You know, they did the wrong thing, but they did everything they were supposed to do. And all the states that they paid fines in have renewed their license. So you're right. You're exactly right. It's very difficult. And we have had a pretty hard rule in the past of you lie, you don't get a license in Colorado.
So board members, and Devin can speak to this as well. One of the things that you have to consider at the state level is rehabilitation. Like, what more does this person have to do to demonstrate to you that they have moved past their past actions?
Good point, Steve.
Good point.
And I had 2 years. And they paid 19,000.
Yeah, so did a lot of the other people who have existing licenses.
And I will say, Shirley, that like when we're looking at the complaint investigations, it seems like there is a significant impact in revocation versus denying with the option to withdraw against the loan officer. So I think it kind of puts us in a little bit of a different position when we're looking at complaint matters versus licensing matters and how to handle.
Okay, and then just a question for my information. If they're allowed to withdraw, how long do they have to wait to reapply?
There's no restriction.
So they could reapply tomorrow.
Yeah.
Okay.
Well, and if you deny them, they could take this to administrative hearing.
Right.
Yeah, so to Marcia's point, I mean, if we deny with the opportunity to withdraw, they withdraw and reapply, and we talk about it in March. I mean, you know, like
exactly right.
Will have changed. Did they rehabilitate? What do we expect their rehabilitation to look like if we don't think that they've met it right now? And I'm not sure that I have an answer for that.
Right.
Like I don't have any expectations of rehabilitation because they've paid everything according to the settlement order. So yeah, I don't have anything else that I can firmly say this is what's needed for you to be rehabilitated, because I think that they did everything.
Right. And I think that's how it would be perceived by the law if they took it to the next step and we did deny them. You know, they did everything they were asked to do.
Mm-hmm.
Right. And to Marcia's point of, you know, what else would they need to do in order to prove worthiness or whatever? There isn't anything that any of us can think of. So that shines a light on
case by case and look at them, but I'd be inclined to approve this license.
That's the direction I'm leaning as well.
So I'll make a motion to approve.
I'll second. All in favor or any further discussion? All in favor, say aye.
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 I am an aye.
I abstain.
And so all opposed? You'll abstain? Okay. Thank you so much.
So board members, licensing matter B is an application for licensure. This is case number 2022-1947. The investigator for this is Tabitha Quintana. On March 1st of 2012, the applicant was convicted of felony possession of cocaine less than 1 gram. The applicant was sentenced to 2 years of community supervision and a fine of $300. The applicant has completed all terms and paid the fine in full. The case is closed. We don't have a recommendation, and Tabitha is here to answer any questions you may have.
Thank you so much. Board members, I don't know, my thoughts on this one just right off the top is this was a pretty long time ago. I feel positive towards this one, and I feel like this is one that we can approve due to the time period that's passed and rehabilitation, what I've read. I feel positive going forward with this application.
Totally
Is there
agree.
any?
And a really good letter of explanation.
Yeah.
Good reference. On board.
Yeah, so I would vote to approve the application.
Okay, do I have a second?
Second.
All in favor, say aye.
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 And
Aye.
I'm also an aye. Thank you.
The next one is matter C. This is an application, complaint number 2022-1687. On January 19th of 2021, the applicant entered into a consent order with the California Department of Real Estate. The applicant's California mortgage loan originator license and company licenses were suspended for 15 days after an audit was completed. The audit revealed issues with disclosures not being provided to borrowers within the required timeframes and incorrectly disclosed fees. The audit also cited that the applicant, who is the president of the company, failed to adequately supervise employees. The applicant and his company were ordered to pay $10,158.35 in fines and audit costs. The fines and costs have been paid and the supervision was stayed for 2 years. The applicant and his company are currently licensed in California. On March 10th of 2016, the applicant and his company were issued a cease and desist order after the state of Oregon's Division of Financial Regulation conducted a desk audit of the company's files. The company was ordered to pay a $3,250 fine and cease and desist from violating Oregon's mortgage loan originator law. The order is signed by the applicant as president of the company. The fine has been paid and the company surrendered their license prior to the discipline being finalized.
Thank you.
We do not have a recommendation and Investigator Martinez can answer any questions.
Sure. Okay, thank you. Board members, this one is tricky for me because I feel like these are egregious, things that are happening here for a company, for somebody who is a controller of a company. And then not only to have one incident in 2016 but then again in 2021, which is just, the other day, it feels like. So, but at the same time, I felt impressed by the letter of explanation, very positive, and just takes responsibility, means a lot to me. I don't know. I really need to have some discussion on this one with all of you.
Yeah, I think I feel conflicted as well. It said that the findings were clerical in nature, but missing disclosures and not including accurate fees to me is not clerical.
Right.
Direct borrower impact. And so I don't think that's clerical. And again, we go back to the control person, someone in a leadership position, I expect them to have integrity and to, do due diligence, especially when they're overseeing, all of their staff. So it is a little bit conflicting.
Yeah, I could almost see the one time 2016, as, oh, okay, that was then, but again, another, serious sort of, accusation is not cool, not good, and really makes it hard for me to just go straight to approval on this one.
Right.
Well, and it's not just one or two issues, it's a whole list of things.
Well, yes, there are many, many violations. Yeah. I just mean time period, but yes, you're right. Many, many violations.
My notes, I pointed out that it's just really sloppy.
Mm-hmm.
Really, really sloppy. And thank goodness for audits, they got their hands slapped. They're kind of learning the hard way. It sounds to me like everything was resolved and that they have, from learning from their errors and mistakes, they've put procedures in place and they've kind of been supervised. And I think they're in a better place now. It's just really sloppy.
Right. Good point.
Personally, I would not deny a license over this. But for the record, very, very sloppy. I agree. But they did pay their fines, rehabilitate. They have new policies in place and they've been supervised.
Right.
So that's what I would hang on to, I guess.
Okay, that's a great point, and I do agree on that. And I would certainly hope that we wouldn't see this responded again before the board for similar issues, because of the fact that they've dealt with them and met all the demands so far. So, would someone like to make a motion?
Make a motion to approve.
I'll second. All in favor, say aye.
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 And I am also an aye. Thank you.
Matter D is an application, complaint number 2022-1864. In the NMLS registry, the applicant disclosed 2 actions taken against the company that she's registered as the agent for. On March 8th of 2018, the applicant's company entered into a settlement agreement with the state of California Department of Business Oversight. The company was ordered to pay a $100,000 fine. The fine has been paid and the company is currently licensed in the state of California. The conduct described in this order does not pertain to the applicant as an individual loan originator. On August 16th of 2019, the applicant's company entered into a settlement order with the Virginia State Corporation Commission. The company was ordered to pay a fine of $20,000. The fine has been paid and the company is currently licensed in the state of Virginia. The conduct described in this order does not pertain to the applicant as an individual loan originator. We do not have a recommendation and Investigator Martinez can answer any questions.
Thank you. Okay, any notes or comments that come out that you would like to discuss, board members?
I think the key on this one is that the actions that happened did not pertain to the applicant or the individual originator. It was company-based and audits and sloppy and massive fines to that company. It isn't individually directed and saying that this individual person is a risk to the public. So again, I'd be inclined to approve the applicant.
I would agree, actually.
Well, I'm a little uncomfortable because she was head of operations and VP of administration during that time. So they referred to her as the control person. So yeah, it's not against her personally, but I would think based on her positions there, it could be concluded that she should have had that she may have had knowledge of this and some involved.
Yes, and I did speak with her about that.
Okay.
She did state that while there was some oversight, she wasn't directly overseeing the employees. So it doesn't sound like that was something that she had immediate responsibility over, although because of her role, there is sort of an inherent culpability, but certainly not as if she was directly supervising the employees.
Okay, Paul, that's great. That's good info.
No.
It looks like they also agreed to move forward with quarterly audits.
Right.
They did, try to make amends to their internal floppiness.
Yeah, and I will say from personal experience, per diem in California is something that impacts almost every company licensed in California. I mean, it's a pretty common finding on an audit. And the marketing piece for, NMLS and address on advertisements, that normally wouldn't fall into an operational role. It might be under an administrative role, but most likely it's under sales. So, it might directly be anywhere in her wheelhouse.
Gotcha. Okay.
Great point.
Yep.
So I make a motion to approve.
I'll second.
Okay. All in favor, say aye.
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 And I am an aye as well. Thank you.
Matter E is complaint number, this is an application. It's complaint number 2022-1951. On January 17th of 2018, the applicant agreed to a deferred sentence of 2 years that included supervised probation for a misdemeanor assault. He incurred court costs and fees in the amount of $1,473.50, which has been paid in full. Probation, however, was revoked and the applicant was sentenced to 180 days in jail. On October 2nd of 2018, the applicant was sentenced to 3 years of supervised probation for a misdemeanor violation of protection order, criminal, and a misdemeanor menacing. Probation was revoked and the applicant was sentenced to 6 months in jail. Court costs and fees in the amount of $541.50 have a balance of $131.50 as of November 29th of 2022, and payments are being made monthly. On March 27th of 2020, the applicant was sentenced to 90 days in jail for a misdemeanor harassment, strike, shove, kick. Court costs and fees in the amount of $297.50 have a balance of $277.50 as of November 29th of 2022, and payments are being made monthly. We do not have a recommendation, and Investigator Gabarty is here to answer any questions.
Thank you so much. Board members, as it is customary with this board, if an applicant hasn't completed their court costs and fees at the time of application, we don't consider that ready for application. And the fact that so much time has passed and there's still a balance tells me that it's not important to pay the fees to the individual. And I would be inclined to deny this license. Your thoughts?
I agree with you.
Add, after reading everything, I didn't come away with the feeling that this person has been rehabilitated.
Yeah, absolutely.
That bothered me more than the fines. Not to get into any detail, but his letter of explanation left so much out that
right.
I don't know that I would go with the not fit 12-10-7-11-1G, that he's just not fit. And I don't know if we want to add that he could withdraw, but I also agree to decline.
Mm-hmm.
Yeah, I felt like the letter of explanation kind of avoided all responsibility, which was in line with what the other parties said about him as a person. And so it was kind of in line with that. And so given that, and then also the lack of importance in paying the costs, it's just very clear that I don't think that there is a good character to approve.
I agree with all that.
I do as well. And the particular comment in the letter regarding that this wouldn't have happened if the restraining order would have been lifted. Well, that's not the point, entirely missing the point. So anyway, is there someone who'd like to make a motion on this?
I'll make a motion to deny based on Rule 12-10-7-11-1G, not fit.
Do I have a second?
And
Thank you. Yes.
Did you want to give the applicant an opportunity to withdraw the application? Is part of your motion?
No.
No.
Okay, all in favor, say aye.
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 And I'm also an aye. Thank you. Okay.
Matter F is an application, complaint number 2022-2217. On October 11th of 2019, the Texas Department of Savings and Mortgage Lending fined the applicant's place of business in the amount of $6,550 after an examination found that the business was in violation of failure to contract a properly licensed loan processor, unauthorized activity, and failure to maintain a proper physical office. Applicant stated, although never licensed in Texas, he was included in the disciplinary action as he was the administrative officer of the business. We do not have a recommendation, and Investigator Gabarty can answer any questions.
Thank you. Okay, any further comment and discussion on this?
I think it's another situation where, you know, the applicant, it was based on the company, what happened. You know, he was in a management position. They were fined, they paid the fine, and, you know, it's been 3 years and he's applying. I'd be inclined to approve.
Yeah, I actually agree.
Agreed.
Okay, then I'll make a motion to approve the application.
Second,
Second.
all in favor, say aye.
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 And I am also an aye. Thank you so much. Okay, I believe that comes to the end of our licensing matters. So that brings us to our ESP matters, and there are currently none on the agenda, but do we have any comment on ESP program manager?
She doesn't have any for you.
Okay, thank you. I appreciate that. And I see there are no attorney general matters listed on the agenda as well. So with that, I believe that we can adjourn this meeting. May I have a motion to adjourn this meeting, or is there any further discussion on agenda items for the next meeting before we motion for adjournment? Any current comment? Okay, may I have a motion to adjourn this meeting?
I'll make a motion to adjourn.
And may I have a second?
I second.
Okay, all in favor to adjourn this meeting today, say aye.
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 I am also an aye. Thank you so much again, board members. You were so amazing, and staff. Thank you from the bottom of our hearts for all your hard work. You guys are amazing, and you make it very easy for us to get through all of the material, and I really, really appreciate it. So with that, this meeting is adjourned, and our next meeting is scheduled for March 15th, 2023 at 9 a.m. I need to say that I won't be able to attend that meeting. So I am so sorry. I hate missing meetings, but I'm going to be traveling for work and I won't even be able to attend remotely that day. So I apologize, but I want to just let you all know I won't be here that day.
Thank you, Madam Chair.
Hopefully we'll have a new board member by then.
Yeah,
hope so.
right. I hope so also.
Yeah.
Hopefully.
All right.
Thank you again, everyone. Have a wonderful day and a wonderful weekend, and look forward to seeing you again.
Stay warm.
Thank you.
Take care.